Hello, everyone. So my name is Ivo. I wear many hats today. I'll share with you two of the hats I wear. So I'm a senior researcher, obviously, at ICF, and I'm also, as of recently, running my own practice called IO Legal, established in Bulgaria. So the title of my presentation, Law Loves Just, with a question mark. Why the question mark? As a lawyer, in my first year at law school, I was trained that as lawyers, we're typically not interested in ethics, really. Ethics is just a subsidiary source of law that may inform the law process, but as such is not something that we deal with on a regular basis. I know this may sound weird to some of you, but really there are legal rules and then there are ethical rules. And in principle, we don't deal with the ethical rules. The ethical rules are really about people knowing what's good and bad. And the law is about achieving some measure of justice to the extent possible, and not always what people believe to be justice. So this is a quote from Brad Smith, who is the president of Microsoft Corporation. In one of his books, he said that as computers gained the ability to make decisions previously reserved for humans, virtually every ethical question for humanity was becoming ethical question for computing. So I don't think we can, continue to, in a way, play possum when it comes to ethics, even as lawyers. We actually have to start thinking about these questions and address them. So when discussing Just with Michaela, when I was first introduced to this project and started contributing to it, the first question for me was, how do I make sense of Just as a lawyer? What does it mean? Does it have actually legal basis in the law? Can we find any traces of just practices in the law? Because just stands for judicious, unbiased, safe, and transparent. And the answer is yes. Just is not just about data ethics. Just is also about legal obligations. As you know, software development and data processing more generally has become an increasingly regulated activity. So this is just an example of the list of applicable legal instruments to data processing and to software development. So to me, software development like healthcare, like safety, like manufacturing and so on, has largely become a regulated activity, which means that it's no longer a legal Wild West, really. It is, there are rules that we as developers and as advisors to these developers have to try and make sense of. So during my search for Just in the AI Act, the GDPR and the Data Act, I discovered a few provisions and I tried to map them onto the different concepts behind Just. So let's start with the AI Act. You may know that the AI Act, which is still not quite officially adopted, so we don't have it published in the official journal yet, but this is expected to happen in the next couple of months, imposes, for the first time, I think, so comprehensively, data management and data governance obligations on providers of AI systems. This provision applies specifically to so-called high-risk AI systems. So think, for example, of remote biometric verification systems or systems used in the judiciary or systems used in education, in employment, systems where the implications on the fundamental rights and freedoms of individuals are actually significant. So the risks are quite high, hence high-risk AI systems. What do these data management and data governance provisions in the AI Act stipulate? Well, there is a comprehensive list, actually, of practices that providers of AI system needs to account for when it comes to managing their data that they use, the training, the validation, and the testing data sets. So, for example, when it comes to judicious, I identify the following practices. For example, providers of AI system must account for the design choices, the data collection process and origin of data, the original purpose of data collection, operations such as annotation, labeling, cleaning, updating. This is all in the law. As a provider of an AI system, you must have this documented. You must not just have this documented, you must have actionable processes that apply what you have documented. For unbiased, it's actually quite detailed what you're asked as a provider to do. You must formulate, you must have a very clearly elaborated formulation of the assumptions, in particular with respect to information that the data are supposed to measure and represent. So any assumptions that you might have when collecting and processing the data sets that you use to train your systems must be documented. You must be aware of them. You must also carry out examination if possible biases that are likely to affect the health and safety of persons, have a negative impact on fundamental rights, or lead to prohibited discrimination. And you must also account for the statistical properties of your data sets, including persons or groups of persons in relation to which high-risk AI systems might be used. So this is all about making your data sets unbiased. So here is the unbiased part. When it comes to SAFE, the AI Act requires providers to implement measures that are supposed to detect, prevent, and mitigate possible biases. These measures must be sufficiently representative and so on and so forth. So you can see that if we try and map what we have behind JUST, it's actually quite easy to find these provisions in the data management and data governance article of the AI Act. Now you may say, okay, I'm not developing a high-risk AI system, why should I bother? To me, this provision, although limited to high-risk AI system, is actually going to have industry-wide impact because it sets the standard for data governance and data management. And I think it will have to be applied, even though it's in the chapter applicable only to high-risk AI systems, it will have to be applied horizontally across the entire AI ecosystem. Transparency, providers are required to document data gaps or shortcomings that prevent compliance. So really compliance is at the focus of this exercise. So it's not just about data ethics, it's also about compliance with the actual legal rules of the AI Act. We can find examples in the basically recitals of the AI Act, which talk specifically about facilitators, how to actually achieve this. So for example, the European common data spaces, which are established with the idea of facilitating data sharing between businesses and governments. They expect that actually accessing the European data spaces, which can be thought of as data spaces organized around the principles of JUST, that they would facilitate non-discriminatory access to health data and the training of AI algorithms and those data sets in a privacy-preserving manner. So what does that mean? It means that JUST can also be embedded, and it has in a way been embedded in the design also of data spaces. So these principles are tangible principles. They exist in the law. It's a matter of identifying them and linking them to what we are trying to sell you here, in a way. There are also business opportunities in the AI Act. So if you, for example, want to see, okay, obviously there are many obligations, but where's the carrot? Well, the carrot, for example, is given by one of the recitals, which stipulates that these requirements related to data governance can be complied with by having recourse to third parties that offer certified compliance services, which may include, among other things, verification of data governance, data set integrity and data training, validation and testing practices. So to me, these are new business models that we're going to see emerging. And it's quite impressive that you can actually find already suggestions of how you could run a business around this compliance mess that the AI Act is going to be in the end, already in the regulation itself. We can find similar provisions in the GDPR. So, for example, when it comes to judicious data practices, we immediately can refer to the principle of lawful, fair, and transparent processing, which tells us that data processing may only occur if there is a lawful ground, meaning you must rely on one of the explicitly listed lawful grounds in Article 6 of the GDPR. So it can be consent, it can be performance of contract, compliance with legal obligations, and so on. You can see in my list here that actually consent is the last one, because even though it's first in the list, you should definitely not treat any of these with priority. So they are really horizontal. They are not hierarchical. Consent is not the first and most important lawful basis for processing. With respect to unbiased, we can find traces of this requirement to be of being unbiased in the provisions that concern automated individual decision making and profiling. So decision based on automated means, on using automated means, must use, for example, appropriate mathematical or statistical processes for the profiling, implement technical organizational measures, specifically measures which factor inaccuracies in personal data and are corrected and the risk of errors is minimized. So this is all again in the GDPR. Data controllers are under an obligation to comply with this. They have an obligation to be unbiased. Same goes for SAFE. For example, the risk of the rights and freedoms to natural persons of varying likelihood and severity might result from data processing which can actually cause not just immaterial but also material damage sometimes. And the GDPR acknowledges this, acknowledges that data processing operations must be safe. And safe being understood not just as safe in respect of the freedoms, of the fundamental freedoms and rights of natural persons, but also safe in respect of actually protecting the physical integrity of people when that might be at stake. With respect to transparency, I think it's all over the place, really. I mean, GDPR is all about transparency. It's all about disclosing what it is that you're doing with the data that you have collected. But one specific requirement stems again from the information that controllers must provide when it comes to automated data processing. So this is the provision of meaningful information about algorithms logic in some of the cases of automated decision-making. And really, I haven't seen a good example yet of what a good disclosure really of the logic behind a data processing algorithm looks like, especially from the terms and conditions and privacy policies I've scrutinized, as well as advising my clients. It's super challenging to provide that level of explanation that actually meets this requirement of transparency, even though we have guidelines of the European Data Protection Board and so on and so forth. But we still don't know, and of course it has to be decided on a case-by-case basis how to discharge this obligation of transparency. The Data Act also contains some indications. I have not categorized them per the just category, but one particular requirement concerns the requirements regarding interoperability of data sharing mechanisms and services. So basically, data holders, data space participants must provide dataset content, use restrictions, licenses, data collection methodology, and data quality, and uncertainty descriptions, basically, of the dataset they are sharing within data spaces, which means, again, that they must follow these values, these requirements that are embedded behind the concept of just. It is also in the Data Act, which aims to facilitate data sharing from manufacturers of devices and as between users of devices and other parties. So, lots of obligations that you have to comply with. Where's the carrot? Why bother? We are not just trying to map what's legally required by participants, but also to create incentives for them. And Michaela already hinted at this idea of building a just community of practice, because just is not intended to be a metric. It actually might become a metric over time, but it's not how this was designed in the first place. It's really about building community of practice. This is a slide from the CNIL, the French Data Protection Authority, which summarizes how they see basically a responsible approach to building an AI system, which of course it all makes sense to anyone who has ever seen an AI system, but it's easier said than done. They actually provide a very detailed template of how data controllers are supposed to annotate their data sets. It's actually 6 pages, I think, in total. And you can see that they require quite a bit of information. Believe me, I don't think many data controllers today are actually following this example, or that they document their data sets so extensively, not least because some of the questions actually require value judgments that these actors are not always well positioned to take, or they don't necessarily ask for the advice that they should take from either their legal or ethics officers. Sometimes even if you find these templates completed in some organizations, you would see that there's no substance behind them. And we actually want to incentivize these people to create this substance, really, to build it and to make these templates actually usable and not just a checkbox exercise. Data sheets about data sets. This is a Microsoft research initiative. I'm very actually happy to share with you about, because to me this is one of the first attempts actually at trying and making the data science community more responsible by integrating a tool within their daily workflows. So data sheets for data sets is basically like a nutrition label for data set. It says, okay, in these data sets, we've identified these and these biases. We may have these and these safety issues, or they are not representative in this and that respect of concerned subjects. So things like this, they have developed actually pretty detailed template called the Author Data Documentation Template, and there are links in the presentations which are going to be shared with you anyway. And they also conducted this study in, I think, 2022, which aim to show how people are actually using data sheets for data sets 4 years after the publication of the paper. The outcome was that, and they were quite honest about their research results. They said, well, the truth is we've only tested with a limited number of participants. Most of them were asked to do this on a voluntary basis. And importantly, there's no tooling behind this. So asking them to, just complete a data sheet is taken as a side task. It's not their main thing. It's not integrated in their workflows. So to us, if we want to create incentives for people to be just, these tools, first of all, we have to build tools, and these tools have to be integrated within their workflows. So I imagine, and you may call me crazy for this, but I imagine one day having just tools, just annotation tools, embedded in every single open source, just annotation tools, obviously, embedded in every single big cloud computing environment where people actually work with data sets and where they build and trade their models. This is the only way to incentivize these people. If we don't reach to them through the tools and workflows that they practice on a daily basis, it's not going to happen. I was also happy to mentor students participating at a hackathon in Oxford in April, who developed a bit this idea of data sheets about data sets by implementing them on a blockchain, which actually allows provenance all the way throughout the entire life cycle of data, through annotations added to the data sets and the respective data sheets. You can check out the project. It's available on GitHub, and there's also a paper to it. It's still work in progress, but I'm super happy that they actually picked that topic and that I was their lucky mentor at the time. Building data products with data sets. This is, again, something from the Data Act, which, again, brings this idea of finding business models to do this. I think that by using just data, we automatically achieve solve this problem of how to build actually data products that respect the fundamental rights and freedoms of people. So really, if we solve that problem at the dataset curation phase, we don't even have to discuss, and that actually also creates an incentive, I think, for people to buy into these products that have a label, but not just a label that alludes to ethics washing, but an actual real label which is supported by practices embedded, again, in the workflows of the people who work with data sets. And just is not alone. We've found synergies with other projects that deal with similar issues like this one, Project Gender Shades, led by Joy Bolomini, who is also a collaborator with the ICF. We have synergies with, we can find synergies with digital innovation hubs who are supposed to actually help companies embed these practices into their day-to-day activities. So they are definitely a customer of the just data specification. Digital sandboxes too. So digital sandboxes are a way of basically providing access to just compliant data sets in a secure environment. This is something that the FCA in the UK ran as a pilot a couple of years ago, with the idea of actually scaling up this idea of regulatory sandboxes where companies can talk to the regulator and advance their innovation under their supervision in a controlled environment. It's something that we have in the AI Act. and that we were quite lucky to submit a proposal recently with Guy Löw and colleagues from RISE and other partners. But again, digital sandboxes is a potential customer, I would say again, of Just Data, because access to compliant data sets is in high demand among companies. And if we can provide compliance across different instruments, we're not just talking about GDPR. In this case, the FCA Digital Sandbox was about GDPR. But if we extend this compliance exercise across the other instruments, then I can definitely see a buy-in from industry. So some open questions to conclude. Why should data operators be just? I think there are plenty of incentives, not just, top down. It's not the carrot and the stick. I think people actually begin to care about the way they process, the way they collect it, and the way they process data. So I think it's the right time to try and build the tools that they can use easily, because we cannot blame them if we don't give them the tools. We can also ask them to put in the extra effort if we don't offer the tools that they can integrate with what they do. Another question, how to share annotations about confidential data sets, because it's all nice and rosy, but not all data sets are commercially, are publicly available, and we can't expect organizations to do that. So how do we actually incentivize these collaborative annotation commons? And related to that, where is the intellectual property? Because sooner rather than later, people start asking questions of, okay, I've been contributing these annotations, and it's all nice and collaborative, and it's all in the commons, but I actually want my IP. And where is my IP? Because traditionally, in intellectual property law, to achieve a level of protection that copyright grants, you would actually need something to be original, which means the author's own intellectual creation. And that criterion applied to a data annotation, I'm not sure how well it would work. So you may end up with data annotation without any IP whatsoever in it. And if IP is not the solution here, then we have to find what it is really for people to, after all, monetize their efforts. Thanks for listening.